Tonya, Gonnella, Frichner. Presentation topic: the impact on Indigenous peoples of North America from the international legal construct known as the Doctrine of Discovery, and consequently the leadership of Indigenous peoples in the development of the United Nations Declaration on the Rights of Indigenous Peoples.
Nyoe Haskana. Thank you. Thank you very much, Nathan, for that lovely introduction, but you can read it in the book. I would like to thank the Shuswap people for inviting me and allowing me on your sovereign territory. It's a privilege to be here amongst all of you. I would like to give greetings, if I may, to the elders, to all of the chiefs that are here. I'm very honored by your presence. The leaders who are here, the youth, the law students, the children, and all the people. It's just terrific to be here in this beautiful country. I'd like to thank the Thompson River University for their kind invitation and for also helping make this important dialogue for the last 2 days possible and happen. And also to the Shuswap Nation Tribal Council. I apologize if I'm not pronouncing it correctly, but I am from the East after all, so you gotta cut me some slack. And I understand that you're very forgiving. My Mohawk sister, Dr. Jen Derrick, said, "Oh, don't worry, they're very forgiving." I practiced, but it still didn't work so great. I have a special thank you to some dear friends and colleagues, and they are Professor Nicole Chabas and also my dear friend and colleague Art Manuel. They are just terrific people, and their vision to bring us here for the last 2 days has been something that we have been talking about for a very long time. And here we are, and it's come to fruition. And I love the way Ron, earlier, our last speaker, kind of pulled everything together. He used our traditional language, he used our traditional stories and culture to pull it all together to say, and this is my interpretation, Chief, that Indigenous peoples have our own culture, our own words, our own governments. We have bicameral governments. We have our own constitutions and laws that are embedded for, could we say, time immemorial. It's because the interpretation of using somebody else's language that it becomes difficult to give what we have and what we have shared with those who have come to this Western Hemisphere a little on the hard side, a little challenging. But they're already there. And what I would like to talk to you and share with you today are a couple of things. I want to go over the Doctrine of Discovery because there are some things that I think you should know that I would like to share with you and that I've had sort of firsthand experience with. And the second is I would like to present to you a little bit of history and explanation on the Declaration on the Rights of Indigenous Peoples that new UN, relatively new, 5 years now, human rights instrument based on our individual rights and based for the first time in international law the protection of a people's cultural rights. Very important for us to always take with us and hold on to. I was wondering, and I think I'm sure on this point, that the last couple of days have sort of brought all of you to a point that you now understand that the doctrine of discovery is a racist doctrine. Racist, from beginning to end. And that, I would like to share with you, is really not sustainable. Racism is not sustainable, neither for developing countries or developed countries and their institutions. History showed us that racism does not sustain or even assist or help sustain a community or a nation. So with that, I think we're a little bit on the same page. And let me get into that doctrine of discovery. I did a presentation for you, and I'm going to sort of stick to it. Hopefully, those two parts that I just shared with you, I can finish with enough time to do questions and answers. That's kind of my favorite point or favorite part of a presentation, getting to speak with the audience and seeing what is missing or what we can share and what I can learn. So if that's all right with you, I'm just going to proceed. We know that early on, upon conquest, it was determined that the Western Hemisphere was void of people. Indigenous peoples were virtually non-existent. That was the mind frame that came to this hemisphere. But since then, indigenous peoples have determined that this is not true. That the Europeans determined that we were pagans, infidels, Saracens, beasts of burden, whatever name you want to apply to it. And that began to make the whole process complete. Indigenous peoples are not human beings. They're because they were not Christian, because they were not baptized. Therefore, the land is empty because there are no Christians in it. And then the argument becomes complete. If it's empty, then you can take it. And thus began that long period of the illegal appropriation of indigenous lands in this hemisphere. Just turning indigenous peoples into non-human beings. And that just set the stage and made it complete. So it became lawful to take the lands, territories, and resources, because they're all connected together. Those resources of trees and land and the pulp mill that I kind of smelled when I got off the airplane yesterday, and I recognized it right away because there are pulp mills in Maine, in the lower states, and they smell the same. And I thought, I know that smell. And then in the plane coming over this beautiful, beautiful land, I saw that there were a few trees missing. I soon found out that the beetles are just having a good old time with the trees, and that the weather isn't getting cold enough to destroy those beetles, which is pretty much what is happening in the United States as well. Climate change and everything else associated with it. This whole attitude of indigenous peoples not being human beings, giving the discoverer or the first Christian nation to arrive the right to take our lands, to take our resources, and to bring with them institutions that had legal constraints based on racism. And they transferred this racism into law and transferred the right of conquest and the right of this conquest between Christian nations. All done nicely, cleanly, on their part, but not so cleanly as Ron shared with us earlier on Indigenous peoples' parts. I know Steve Newcomb shared with you the Doctrine of Discovery as a doctrine of dominance, and for sure that is what it is. But you also have the law of nations, you have the law of Christendom, that all became intertwined and eventually became international law. And this is where we are today. Domestically, we see the extension of the Doctrine of Discovery in that infamous Supreme Court case from the United States, Johnson versus McIntosh of 1823. I believe that Walter dealt with that yesterday and did a fantastic job. I apologize I couldn't be with you yesterday, but I had to come a little bit later. But here I am, and here I am able to absorb all the other wonderful information that is coming forward. What the Supreme Court did in Johnson is that it manufactured a concept of American Indian land title. This helped open the West, the western part of the United States, for expansion. This was very critical and something that influenced the court's decision. So based on the concept of discovery, the court constructed an Indian title of mere occupancy, not ownership, not title, but just occupancy. Like you can rent an apartment and be an occupant, but you don't own it. Or rent a house, be an occupant, but don't own it. So this very less than now new type of title came out of that Supreme Court decision. And it also confirmed that countries that were unknown to Christian people had to follow those rules, had to follow those restrictions. And what it did, that ruling prevented the application of one of the first principles of international law. And that is, of a nation within its own territory is absolute and exclusive. Now, many of you may know the contemporary version of that principle, which is the territorial integrity of nations, protecting your borders, nations not allowed to go into another nation without permission or some kind of process. And we see that all the time. You see it with the United Nations right now, where the civil society wants to see some kind of intervention done in Syria. But in order to do that, the United States, as a member of the United Nations, one of the 191 members, has to gain support and has to gain permission, so to speak, from the Security Council. And the Russian Federation and China will not agree to it. And if you take it a little step forward, you begin to realize that we're talking about the territorial integrity of Syria. And what does that mean to other countries such as Russia, China, the United States, France, England, the members, the 5 members of the Security Council, and the only body within the UN that has a veto process. The rest of the United Nations operates by consensus. So one government can very easily maneuver a whole political movement. But why is that important? Why is the territorial integrity of a nation state any more important than the territorial integrity of an indigenous nation? I think that's the question that we've begun to ask ourselves for some time now, especially at this conference yesterday, sort of that implied question: why is our integrity as a nation any less than a member of the UN, another nation state? Let me share with you some contemporary issues and things that have gone on the last 20, 30 years. In your packets, you will find a communique number 15 from the Traditional Circle of Indian Elders and Youth. And it's dated 1992. And I asked Kelly and I asked Nicole if we could share that document with everybody here. And the reason why I asked that is because in 1992, and that was some years ago but rather recent, the elders came to a decision that this doctrine of discovery needs to be addressed. And they addressed it in their communique, they described it, they addressed Johnson versus McIntosh, and they came up with a conclusion and a recommendation, which was they recommended that the current Pope, John Paul II, would issue a memorandum repudiating and taking back those papal bulls that Steve Newcomb shared with you yesterday. Of course, it wasn't done. It hasn't been addressed. Steve Newcomb did manage to get into the Vatican by accident a couple of times, just sort of strolled in. And he was also the one who carried that message to the elders gathering in 1992. What is this? We need to address it. And here we are in contemporary times. Some of you law students just born, other of us being around for a long time. But here it is, and we're talking about it, and we're looking at it. But I would ask that you don't look at it in, as Ron would say, ancient terms, but in a way that reflects its application today. That Johnson v. McIntosh case in 1823 that was written by Chief Justice John Marshall established the doctrine of discovery as current law. Current, it's modern. It hasn't been overturned. It's still there. In fact, in 2005, and I'm going to refer to, and I apologize, to United States cases, because those are the cases I'm most familiar with. The case I want to share with you is in 2005, the case called the City of Sherrill, New York versus the Oneida Indian Nation of New York State. What that case was all about, that did make it to the Supreme Court, as you know, the highest law of the land in the states, was the Oneida Nation had purchased some land on their original adjoining territory. By 2005, the Oneida Nation that had had millions of acres as part of its traditional territory was now reduced to 32 acres. Just a small little sliver. And they began purchasing some land in their traditional territory. Well, the City of Sherrill, which is a little tiny town that you drive through, you blink, and you haven't seen it, sued the Oneida Nation for property taxes. Well, in the United States, Indians are not taxed. That is the language in the U.S. Constitution. So what does that mean? Well, it meant that the United Nations did not have the responsibility, nor did it see itself as a resident or part of the tax-paying base of the City of Sherrill or the county or the state of New York, which is where it's located. Well, this case made its way up to the Supreme Court, and talk about reliving 1823 all over again. The decision noted on the first page by Judge Ruth Bader Ginsburg, the Doctrine of Discovery, that it still applied, that this land had been conquered and belonged to the discoverer. It just left you speechless, absolutely speechless. This has not been overturned, ladies and gentlemen. It is still the law of the land of the United States. And as I understand it, you have a similar situation here in Canada. So the rhetorical question is this particular doctrine and issue something that we need to deal with now? Yes, yes it is. It's something we need to deal with now. And I would propose that this conference, that this wonderful gathering, think about investing in the time and energy to make that possible. The second decade of the world's indigenous peoples talks about indigenous peoples working in partnership with civil society, universities, governments, and that partnership we see as an extension when we are working with the university systems. And I think that this may be something that you might want to consider addressing, since you're already doing it today, since the foundation has already been laid, bringing it forward. That would be my recommendation. And Chief Lyons and Nathan, correct? And Nathan were talking a little while ago, and the discussion was a legal journal, a document, a paper, an official paper of some sort needs to come out of this gathering. Nothing helps this struggle and this movement more than a document from a university, an institution such as this. And we all need it for our work. I would be happy to carry around a journal from this university saying, this is what these experts have been saying. We already know what the other side has said, but the documentation of our side, indigenous perspective, about law, about jurisdiction, needs to be documented over and over again. We have some great authors here. I know Bob Miller has a book coming out and has had several books. Steve Newcomb has a terrific book on the Doctrine of Discovery, and I think it's called Pagans in the Promised Land. Chief Lyons has a book called Exiled in the Land of the Free that talks about and makes the case, a very clear case, that the Iroquois Confederacy Great Law of Peace was the influence of the United States Constitution. I recommend it as great reading, especially for you as law students. Let me share with you, after 1992, with the elders coming forward with this communique, 17 years later in 2009, in my capacity as the North American Regional Representative to the UN Permanent Forum on Indigenous Issues, which you notice takes a couple of breaths to say. Nothing is short at the UN. Everything is long. titles are 2 sentences long, so your wind has to be pretty good. As the representative and also as vice chairperson of the Permanent Forum, I was appointed special rapporteur to do a preliminary study on this doctrine of discovery. And being that pretty much all expert papers at the UN are done collaboratively, I worked with Steve Newcomb, I worked with Chief Lyons, I worked with Professor Peter DeRico, and came up with this study that you also have in your packets that really begins the concrete foundation of this whole doctrine and what it has done and meant to indigenous peoples through the centuries. But it's just the first step. The recommendation that we made for that report was to ask the Permanent Forum members to do a global international study of all the 7 regions. Those are the regions mandated to the Permanent Forum. Have experts come in to do all of the regions: Africa, Asia, the Russian Federation, Europe, where the Sami resides, North, Central, and South America, the Pacific, and come up with this document that we all can use that is a UN document that says this is what we have, this is what we know, that will help us further our work. Well, what we decided to do as a collective this past June in New Mexico, we call it the Tamaya Declaration. The 200 indigenous peoples who were at that gathering in New Mexico on Pueblo land declared that we would make the commitment to do a global study. We would do it in collaboration with the chairperson of the Permanent Forum, which is Grand Chief Ed John from British Columbia. He's the North American representative, but we will do it. And what we want to do is have that study done by 2014, when the World Conference on Indigenous Peoples is held in New York, which will be September 22nd, 2014. A world gathering, and out of that conference will come an action plan, will come a statement that will probably have a great deal of focus from member nations. So it's important for us to deliver our messages to that conference in the preparatory meetings, etc. And this gathering is the first step, one of the first steps. There's another conference that's going to be held in Phoenix, Arizona, by our friend Tupac Enrique Acosta, and others throughout the country, through the U.S. The University of Massachusetts at Amherst will do a similar conference to this in a couple of weeks, and the special rapporteur on the Rights of Indigenous Peoples, Jim Anaya, will be at that conference. I've also been invited to that conference, and this will be a time that I will use to bring the message from this gathering to the East Coast and to the special rapporteur. Speaking of the special rapporteur and the process that we have gone through these many years within the UN system, in 1977, we have several, indigenous peoples now have several different human rights mechanisms within the UN system that you should know about. The first one that came to be was in 1982, called the Working Group on Indigenous Populations. What that came from was a gathering of North, Central, and South America indigenous peoples in Geneva to talk about the discrimination against indigenous peoples in this hemisphere. Leaders, there were like 156 different leaders. The Haudenosaunee sent a delegation of about 40 plus leaders. And it was also at that time that our people traveled on our passports that were issued by our nation. So the whole lot of our folks went to Geneva, Switzerland with a document that the international community and the United States had never seen before. But they stood by their guns, they did it. It was an arduous process, but they were allowed into the country of Switzerland using those passports for the first time. And I share that with you because today we seem to talk about indigenous sovereignty so freely. It just sort of flows off our lips. Sovereignty, sovereignty, sovereignty. But what is it? And how does it apply to indigenous nations? What we learned, and I'm giving a Haudenosaunee perspective, is that sovereignty is an action. It's an act. You either are sovereign or you're not. You either act sovereign or you don't. It's a very clear action. And one of those actions was to travel to this international United Nations conference with our own passports. That was the action, that we would go to Geneva as sovereign nations and talk about our government, our rights, and our traditional ways in partnership as equals. Not in somebody else's court that makes you feel less than, where you're not on a nation-to-nation level. And that also seems to be a term that sort of flows off of the other side's mouth a great deal, that the United States has nation-to-nation relationships. When in effect, when the Declaration on the Rights of Indigenous Peoples was adopted by the UN General Assembly in 2007, 5 years this month, there were 4 governments that voted against it: the United States, Canada, New Zealand, and Australia. And not to beat a dead horse, but those are the realities of what indigenous peoples who worked in this forum for close to 30 years were dealing with constantly, on a daily basis, every time we went to a meeting. There was a struggle over language of the articles in the Declaration, language over the preamble of the Declaration, and it was a constant battle. So to have this declaration adopted by 2007 in contemporary times, and I literally would like to share with you that I did not think the declaration was going to get passed in my lifetime. We spent 14 years in Geneva at the open-ended working group, another breath, on the draft Declaration on the Rights of Indigenous Peoples, on language and policy and principles. But the fight brought us to this point, that Article 3 in the Declaration confirms our right to self-determination as indigenous peoples. And if you look at Article 3, and dear law students, look at Article 1 of the 2 human rights covenants, and you will see that the language is exactly the same. Indigenous peoples were not looking for a new form of self-determination or a new form of human rights. We were looking to be peoples with an S, and to be human beings and treated as human beings as everybody else in the world. Okay? Not populations, not groups, but peoples. Because peoples meant, and our leaders understood that in 1977, that meant that we had the right to human rights, but we were considered human beings. or peoples who had the right to individual and collective rights at that time. But now we do. Okay, so what does this declaration look at, and what does it bring forward? Well, the right to self-determination, and also some principles that indigenous delegates had to fight for, literally, time and time again. The principle of free, prior, and informed consent. A basic minimum standard that is applied in any situation that affects indigenous peoples. And once you put in the extraction industry in that equation, you begin to understand what free, prior, and informed consent is all about. An important principle, and it is in the Declaration on the Rights of Indigenous Peoples in about 3 articles. Important piece. Something that the North American representatives fought for 30 years, treaties. You'll see Article 37 addresses treaties. And the language was, again, a bit of a struggle, but we have it in there. And isn't that what you're talking about today in British Columbia? Treaties. Decades and decades of a relationship with governments that always comes back to our right to self-determination, and free, prior, and informed consent is an extension of our right to self-determination. But it always comes back to treaties, doesn't it? Are those treaties the supreme law of the land? Are they law? And what supersedes, international law or domestic law? Well, in international law, it's international law. It's human rights that supersede domestic rights. And we all need to sort of keep that in mind. Right? We're always kind of thinking on a domestic level when if we kick it up a notch or two, we begin to see what this whole international thinking and forum and conferences and rights are all about. It's all about us as peoples. The Charter of the United Nations. It's the Constitution of the United Nations that all its member nations are responsible for. Talks about foundations of behavior that apply and must apply to all nation states. But there's 3 foundations within the Charter that are important to us as indigenous peoples. One is human rights. Well, the UN has addressed that human rights piece in now the Declaration on the Rights of Indigenous Peoples. The second has to do with treaties and how they must be respected and applied correctly between member nations. And the third is about social and cultural rights and the comfort of all human beings. That human beings have a right to many things: education, housing, health. If you look at the Universal Declaration on Human Rights, you will see all of those listed. But where are indigenous peoples in contemporary times now? We are at the bottom of the ladder. As Bob Miller said last night, 30%, really 80% unemployment on Native nations in the United States. 1 out of 3 Native women will be attacked and sexually assaulted in her lifetime. And those are statistics from the United States Justice Department. That our health, our children, and everything else, it is at a very low point. Well, we need to address that too. We need to address it by using some of the tools that folks have worked very hard to create. The Declaration on the Rights of Indigenous Peoples, I personally see as another tool for our work in our arsenal. I don't see it as the be-end and be-all of everything. It's a minimum standard document, minimum standard, and we had to fight for that language. There are some points that we didn't agree with, but we got an agreement between indigenous peoples and nations, and it was brought forward. So we have a declaration. There's also the Charter of the United Nations. If you're a member nation, you must abide by that constitution, by that charter. You cannot violate it. In order to be a member, you have to follow that rule. The human rights covenants, 2 of them, that most of the world's countries have adopted or ratified in their own domestic governments, in their own domestic way, are tools that we can use. And they are law. The Declaration on the Rights of Peoples, 1948, and there it is. It was first a declaration. Right? And people will tell you, and I don't necessarily agree, that a declaration is not binding, legally binding. But if you look at the history of the Universal Declaration on Human Rights, it came forward as a declaration. And over the years, over time, it became common law, so that every country in the world agrees. And every jurisdiction, every court agrees that it is international law at this point. And that is the trajectory that we're on with the Declaration on the Rights of Indigenous Peoples. It's a terrific thing, but we also can use it and need to use it. The implementation of the Declaration has to come domestically from governments. It's out there, but now who's going to implement it? It's a responsibility of the nation states, of the UN, to put that forward, to make it part of their domestic law. But I'll give you what some governments are looking at in terms of the Declaration. As I shared with you earlier, 4 countries voted against the Declaration. The first one to sort of backtrack, revisit their veto, was Canada. They looked at it, they supported it, but there was a bit of a caveat, a bit of a reservation, that this declaration would be implemented domestically as long as it didn't interfere with domestic law. And didn't I just share with you a few minutes ago that international law supersedes domestic law? So we have that little conflict right there. Right? Canada took that leadership role in bringing Australia and New Zealand to the table and getting the Declaration adopted. And by 2010, the last remaining country that vetoed the Declaration was the United States under the Obama administration. However, it was great to hear. It was wonderful that it happened, but it didn't adopt the Declaration as most countries. It supported it. That's very different from endorsement, as you know. But it also said, the State Department of the U.S. also issued a statement with the support of the Declaration when it was announced. And it's very curious, and you should take a look at it, law students. The U.S. says something about the Declaration developing a new form of self-determination. Now, if the U.S. is saying that, then the Commonwealth countries will be looking very closely at that and applying that same standards, as will other groups of countries throughout the world. Very, very, I think, sort of dangerous presentation, a new form of self-determination. What does that mean? I don't know. The United States wasn't clear. But if we go back to the adoption of the Declaration, aren't we talking about a universal form of the right to self-determination as it reads in the Covenants on Human Rights and as it reads in Article 3 of the Declaration? So we need to keep our antennas up, because this is going to be creeping into the dialogue and into our work, I think, sooner than we think. I'm just going to look at my notes, if you don't mind. And, of course, I went off my presentation. But in reference to the Declaration, what I think it has done is that it addresses the violations against Indigenous peoples inflicted by the Doctrine of Discovery. And it basically said, after that adoption, I think we would all agree that now racism against Indigenous peoples is over with that adoption. Well, we also have a responsibility of breathing life into that declaration. We need to put it in our pockets, in our backpack, in our handbags, and carry it with us. Quote it in your writings, quote it in your presentations, quote it in your tribal councils, and use it. Because if we don't use it, governments certainly aren't going to. Right? It wasn't governments that took on the role of saying Indigenous peoples need to be protected. Their human rights, their individual, their collective rights are being violated. It was Indigenous leadership that took on that role. Governments will stand back and observe. We have to be the barometer. We're the ones that have to kick everything forward and make it happen. It's our responsibility, and it just hasn't changed over the decades. It's our people that make it happen. So we talked about the charter, the UN Charter, and I would say that the Declaration was a seminal moment in our history because it initiated a new era in which Indigenous peoples insisted on a seat at the international table. Not in the gallery at the UN, where we watch like tourists, but down in the bowels of the UN, sitting with governments, talking about our issues on a nation-to-nation level. And that, I believe, is what we need to bring back to our communities as well. How am I doing time-wise? Oh, wow. I blabbed that long? Good grief. Well, then I'll start to wrap it up. Because I wanted to get to some questions and answers. I think I've made the point that the Declaration, the Doctrine of Discovery, is rooted in some archaic thought, but it's very much alive in a contemporary sense, and that we need to remember that. That I would like to see, and I think all of you would like to see, that the rest of the world begins to hear and listen to Indigenous peoples as leaders. We have much to say about the consumption and destruction that's going on with the world today. And we need to be and are the voices of leadership in those issues. And we're the voices of leadership in our own issues and have been for a very long time. Thank you so much for your attention and your kind attention. And let's take some questions and answers. Thank you.
Thank you. Thank you. Questions?
Don't be shy. Be happy to. The question was sort of the difference between the term peoples versus populations. Peoples is a term where the association of human rights applies. Populations, groups, human rights do not apply to them. Peoples are part of the human spectrum, very much so. And as I shared earlier, the fight within the UN with Indigenous peoples and governments were just getting the S attached to peoples, to people. And it took a couple of decades to get that moving. As you'll begin to recognize, it's the Working Group on Indigenous Populations. It's the Permanent Forum on Indigenous Issues. And what we need to do is to begin to substitute that language to what the real language should be, which is peoples. We're in a kind of time of apologies, that governments are making apologies for their boarding school policies. Government of Canada, Australia has issued policies, but attached to those apologies are this idea of reconciliation. And I say that because in the Declaration on the Rights of Indigenous Peoples, there is a discussion, a statement on redress, on restitution, and on reconciliation. And I think we all need to be clear that those three terms have different actions and have different meanings attached to them. Do we want an apology, such as reconciliation, or do we want redress? Do we want restitution? Are we talking about the return of our lands and resources? I think these are things that we should be talking about because they're very important in this time of apologies by governments to Indigenous peoples. The apology, I believe, should come attached with something, right? And the something is something that we as Indigenous nations and peoples need to decide what is it going to be. They took your brain, pulled it out, swished it around, and literally brainwashed you, right? Is the sorry enough, or do we want the next step? And I think that's a question that I would pose to you.
Thank you.